got us going?
Yeah, actually not.
Okay. We are on the record in the cases of originally filed as Wesley, State of Nevada versus Wesley Glenn Dick. Mr. Dick has since informed the court that he wants to additionally go by his Native American name, which is, as I understand it, is Quassa. So we're going to go forward under Quassa Wesley Glenn Dick Jr. for the rest of this, or these cases. And the cases are, if I can get down to it. Case number 12CR013 and case number 12CR019. Is that correct, Ms. Clerk?
Yes.
Okay. Today is the day set for both a prelim and a trial in this matter. My understanding is that the parties have had some issues regarding discovery and witnesses. First off, I'd like to ask the defendant, have you asked for any discovery in this case? Do you know what discovery is?
Yeah. Yes, we did.
What did you ask for?
We asked for discovery 2 weeks ago or so.
Okay, by phone call or how?
Facts.
By fax. Did you receive a fax from the defendant?
Your Honor, we received a fax last Monday before we came here for the
Okay.
oral arguments.
Did it ask for discovery?
It asked, it was from a non-Nevada attorney
Okay,
asking for that, and so we were here on Monday to,
okay. Was there anything from Mr. Dick asking for discovery?
not that I'm aware of, it was the, let's double check really fast. There could have been something Friday we received. Let's see here.
Prior to Friday, was there anything?
No,
I asked Ms. Spotterbear to do it for me.
Okay. You asked that, though, after you were incarcerated, probably, correct?
No, before that.
Before that, okay. But you'd have no knowledge of her having actually done that other than possibly? You have no knowledge of her having done that other than possibly through an attorney out of state?
I have the papers asking.
Can you find where you asked for discovery in your papers?
The motion was received by the Austin Justice Court on September 30th.
Okay. That's the, okay. And we faxed all that stuff correct to the district attorney's office?
I would imagine it is.
Can I, if you would, can you show the sheriff where it says you're asking for discovery? Can we unlock one of his cuffs? Whichever one he is, right-handed or left-handed,
Which hand did you do both?
or both of them is fine. I'm not, the reason he's in custody mainly, Sheriff, is because of the failure to show up. He was a bit unruly, but that was verbally unruly. I'm not that afraid for my physical safety. clerk.
Hmm?
Is this something that you fax to the DA?
Yes.
Okay, would you show that to the DA? This is the second page. Do you recall getting that document? Ms. Elquist?
Yes, Your Honor, we received the fax from the court.
Okay, you notice where it says on there, it does say a motion for discovery?
Yes.
Okay. Is there some reason that you didn't send any discovery to the defendant?
Yes, Your Honor. Let me just give a little bit of background here so I can make the record clear. We filed the complaints in June, and then Mr. Dick filed a motion to dismiss based upon jurisdiction in August 12th. Oral argument was set for last Monday, September 30th, on the issue of jurisdiction. I filed an opposition to that on August 26th. I sent it to Mr. Dick, certified mail and regular mail, and it was returned, the certified mail.
Did that contain discovery or just the response?
No, that was just responding. At this point, there was still the issue of if he was gonna have an attorney or not, or represent himself. So, on Monday, when we appeared for the oral arguments on the jurisdiction, I have the discovery here for his signature if he was gonna represent himself. I was wanting to request of the court to make sure there was a...
That's enough. I get the gist of it. Your grounds for not providing discovery I find valid, and you are excused from having done that. Mr. Dick caused his own problem by not being here. So the lack of discovery is not going to be grounds for any sanctions in this case. But, let's see, I guess, let's go to the jurisdiction. I'm gonna put some things on the record. We're not gonna argue it. I'm gonna try and get through this as rapidly as I can today.
Okay.
Mr. Dick's arguments have been that we are without jurisdiction as the state of Nevada, even though it is my understanding, at least all the arguments to date have been along the lines of that Mr. Dick was, and the probable cause showed that he was picked up for the alleged violation outside of any Indian reservation. He was on the public lands of this state and not in an Indian reservation. That's critically important because the state statutes provide, I believe it's 502.280 for Native Americans or to be able to fish and hunt on reservations without paying for a fishing and hunting license.
Can I see that statute you're talking about?
After we're done, NRS 502.280, resident Native Americans exemption from fees for hunting and fishing licenses, application for free license, requirements for big game tags. Directly on point to whether or not we have jurisdiction is a Nevada case out of Fallon, of all places. What a coincidence where Mr. Dick is from. It is from the Supreme Court of the United States, and it is called Nevada et al. Petitioners versus Floyd Hicks et al. It is 121 S.CT.2304, or Supreme Court Reporter 2304. And it is, the case number is number 99-1994, was argued March 21st, 2001, and decided June 25th, 2001. In that case, the United States Supreme Court invalidated the attempt by the Fallon Tribal Court to stymie the efforts of state officials who were investigating the taking of of desert bighorn sheep at the defendant's, at the respondent, Mr. Hicks' residence on the Fallon Indian Reservation. And the Supreme Court held in a unanimous decision that the tribal court could not handle federal civil rights cases, and that they had nothing to do with game violations or alleged game violations that occurred off the reservation. Those belong to the states. I'm not going to go into all of it. I've given you the citation. You can read it on your own time.
I believe there's more to that case.
There may be, Mr. Dick, this isn't a negotiation. We're moving on. The other part of the court's reasoning is that under a variety of early cases in the United States, in the U.S. Supreme Court, and I'll just quote from one of them. It goes as follows. At common law, the title and dominion in lands flowed by the tide water were in the king for the benefit of the nation. Upon the water were in the king, upon the American Revolution, these rights, charged with a like trust, were vested in the original states within their respective borders, subject to the rights surrendered by the Constitution to the United States. The new states admitted into the Union since the adoption of the Constitution have the same rights as the original states in the tidewaters and in the lands under them within their respective jurisdictions. That is from Phillips Petroleum Company versus Mississippi, 484 U.S. 469, 473 to 474, 98 L.Ed. 2nd, 877 at 844. 108 SCT at 891, a 1987 case quoting Shively versus Bowlby 152 U.S. 1 at 5738 LED 331 at 352 and 14 SCT 548 1894. The reason that matters is this quote. When the revolution took place, the people of each state became themselves sovereign, and in that character hold the absolute right to all their navigable water and the soils under them for their own common use, subject only to the rights since surrendered by the Constitution to the general government. That's Martin versus Waddell's lessee, also known as Martin versus Waddell, 41 U.S. or 16 PET period, 367, 410, 10 LED 997, at 1013, an 1842 case, quoting Johnson and Graham's lessee versus McIntosh, also known as Johnson versus McIntosh, 21 U.S. 8 Wheaton, 543, 5 at 595, and 5 LED 694, which is from 1823. The reason that the water's under the state, I just knew about that because I had to deal with a case having that. The reason that matters is that all of the incidents of sovereignty from the Crown went to the states. Only the ones granted by the Constitution went forward. One of the incidents of sovereignty is the power over game.
Could you repeat that?
The power, one of the incidents of sovereignty that went from the Crown is to the people of the states is power over